Good evening. This is John Milburn for Laws 12063 Advanced Statutory Interpretation and Drafting. This is week 12 of Term 2, 2018. This is our last session. It's been an absolute pleasure to be your coordinator this term, and I came in quite late, so it's been a privilege to work with you, somewhat from my perspective, unexpectedly. But tonight we're dealing with the specific topic of wills and contracts. This is, of course, a very important practical area for those of you that are going to practice as lawyers. But if not, it's still important because almost everyone will or should have some engagement with the topics of wills and contracts during their lifetime. So this week, the material centres around your ability to essentially draft material. But of course, when you draft material, you must first plan it to be effective. And then, having drafted the material, in order to execute the will or the contract, it needs to be prepared with some degree of precision. The material that we have available for you to read this week is excellent. There are 2 articles, and I urge you to read these if you haven't already done so. The first is The 10 Worst Faults in Drafting Contracts by Duke Mcdonald. This is, from my perspective, one of the best articles that I have read about the desire to write in a simple manner. And the other, which is also extremely good, is by Thomas S. Word Jr. It's now a little old, it's 1980, which makes it quite remarkable because when Mr. Word wrote this article, it was at the start of the plain English push, or plain language push, in a real sense. So when I started studying and practicing in law, we were very much still using Latin terms and flooding documents and flooding information with unnecessary words. So for my little part, I would like to, and perhaps grandiose to even suggest it, say that I feel that I've been part of this process of change, only to a very modest degree compared with others. But can I just explain what it was like when I started? I would see these documents written in a very dense and confused manner. Long sentences, unnecessary words, words I didn't understand after being at law school for 6 or 7 years. And I would ask people why it is that we commence a deed using the word witnesseth. I've never heard that word before, but I saw it written often. And the best answer that people could provide, generally speaking, was, well, because it's always there. It's part of the precedent. What if I take it out and I write in a more simple manner? Well, I wouldn't recommend that because that's the way we do things. So for a while, you do that until you start to realize that this is a self-fulfilling thing. And if you read the material that we've got for you this week, you'll see that some of these bad habits literally go back to the 13th century. And the material by Duke Mcdonald is excellent in that regard. And you can understand why it happens, because someone new coming into the profession sees something that apparently has always been, asks a question, you get a response, well, it's always been like that, don't change it. And it's very easy to fall in line. So this generation of lawyers collectively has, with others, worked on changing that. So what you see now is considerably different to what it was like in the early 1980s. Much more sensible, but we've still got a way to go. In the article by Duke Mcdonald, he commences his words like this, and I think it's a terrific introduction. And I'll just read it. If you have it, call it up on the screen, follow what I'm saying. If you're watching this as a recorded session, please find this article. You'll find it, I think, on Hein Online. Duke Mcdonald says, I hate legalese because it forces me to study. That's honesty. I like good prose because it allows me to read. Study tires me out. Reading can be a pleasure. The best writing, and legal writing is no exception, allows readers to read and does not require them to study. I'm eager to do anything I can to encourage more reading and less study. So, I'm exposing the 10 worst faults I see in drafting contracts. That's really well written. And you'll see when you read it that it's a lot of short sentences, broken with some emphasis in certain parts, and overall it reads really well. So can I commend that to you as, if you like, the modern approach to writing in law. I'll go on and highlight a couple of other things from that article. Worst faults, number 1. Using words that were once the coin of the realm but have no modern currency. Oh, that's a great heading. And he says, witnesseth and whereas. These are really hard words to say because we see them written, but I never say them. Witnesseth and whereas have no legal effect, but I see them all the time in my work, says Mcdonald. Witnesseth is founded on a misunderstanding. The word is not a command at all. It's a third-party singular verb, that is to witness. This agreement witnesses that whereas the parties. Whereas, like witnesses, is a holdover from the 13th century and beyond. It has persisted, I believe, out of ignorance and fear. But lest I project my own shortcomings onto others, I will speak for myself on this point. So again, really good writing, but you can see how this has just perpetuated. So if I see in your writing, for me to assess some legalese, you can imagine the groan that I feel as to why we've included these unnecessary words. Speaking of unnecessary words, there is some good commentary in that regard by the other author, Thomas Word, who speaks about the necessity in drafting wills to have an economy of words. So let's have a look at this is on page 472 of the article, if you'd want to follow this. But he talks about the last will and testament of John Quincy Doe. And this is the before. I, John Quincy Doe, now residing in the city of Richmond, state of Virginia, being of sound mind and memory, do hereby make, publish and declare this to be my last will and testament, hereby revoking, annulling and cancelling any and all wills and codicils heretofore made by me. It's very common. That's the sort of wording that we would see and we're encouraged to use. Mr. Word says, that's 49 words. Would not the following do just as well? I, John Quincy Doe of Richmond, Virginia, make this will and revoke all earlier wills and codicils. Absolutely. It's better than the first because of the economy. It's much more easy to understand and read. And as a result of that modern approach to drafting, the drafter has lost nothing from a legal perspective. And in fact, possibly has gained something. Because the more words you include, the more likely that the person reading the material will start to consider whether the justus generis rule should be applied to the circumstances, and whether, therefore, by adding this long list, you are actually trying to restrict rather than broaden the drafting approach. I hope that makes sense. So I commend those two articles to you to read, both for the quality of the writing and, importantly, for the content. And of course, when I saw in Mcdonald's article, number 2, writing in the passive voice rather than the active voice, you can imagine how there was a little yee-haw moment for me. Oh, another good one, and again this is from Mcdonald, is agreeing too much. And we used to see this a lot in drafting contracts in particular. There used to be this emphasis on having so many statements about an agreement. So he says contracts should not start with this agreement entered into, then say, it is therefore agreed as follows, and repeatedly say it is agreed, or it is further agreed, or it is expressly agreed, because you don't need any of that. And he suggests that we delete all those sorts of phrases. It was expressly agreed 3 times, it was understood and agreed twice, and just state agreement and then say what it is. Why do you need to keep saying it is hereby agreed, it is further agreed, it is expressly agreed? It is agreed. If it hasn't been agreed before, it is agreed now. Do you understand what I'm getting at? So a lot of superfluous wordage that we simply don't need. So when you're drafting wills and codicils, please ensure, and contracts, that you restrict your wording as much as you can. Now, just a word on codicils. We don't use them very much anymore. Can anyone tell me why we don't use codicils in practice, realistically? Any ideas? In order to answer that, you need to know what a codicil is. So do you know what a codicil is? Thanks for the honesty. A codicil is an amendment to a will. So it would be that the will was drafted, and then if, for example, the testator chose to change the nominated executor, rather than redo the will entirely and have it signed again afresh, there would be this amendment, this codicil, and the codicil was signed in exactly the same way as the original will to be effective. So again, early in practice, I would have situations of having a will and a codicil, or maybe a number of codicils that attach themselves to that will. Why do you think we don't have codicils anymore? Well, firstly, they need to be signed in the same way as a will. So there's no saving in terms of time for signing or the requirements of signing. You still need 2 witnesses present at the same time of the testator or testatrix and present at the same time as each other. That still applies. The answer is because in the early 80s, these wonderful things called word processors. Originally, it was memory typewriters. When I first started, memory typewriters with a little tiny screen, and it was amazing because it could remember maybe a paragraph, and you could sort of key in a code, and a paragraph would enter into your document. But it wasn't long before we had PCs, and so that changed it. So why would you bother just doing a codicil? Just do a fresh will. It's just as easier to see that. All right, and codicil is C-O, how do we spell codicil? C-O-D-I-C-I-L, I think. Gosh, we just don't use them anymore. Codicil. Anyway,
That's
so having given you that background, you don't have to worry about them too much. Yeah, sorry, Greg.
No, that's correct. I just looked it up under the Australian Legal Dictionary, John, and it's very wordy, and I like what it is that you've actually put it to, and it basically backs up what you said. And I remember in my own case doing my own wills relatively recently. It's just far easier to do a new one and knock out the fact that you had you basically, you're not acknowledging any further the previous will.
Great. Thank you, Greg, for that contribution. And that's a good resource, that legal dictionary. All right, so you need to ensure, of course, that there is certainty. Simplicity often makes for certainty. And remember, when you're drafting documentation, bit of Latin here, the contra proferentum rule, which means that any ambiguity in the drafting of a will, contract, or document generally will be construed against the party drafting it. So that's the penalty for drafting something ambiguous. You'll see in the study guide some key terms. Ambulatory in the context of a will means something that might change over time. So, for example, if you're leaving my car to a beneficiary, it may refer to one car at the time of writing or another car at a later time. So that's an ambulatory provision. Estate means that which can be distributed under a will, although we have an intestacy which is the estate administered by reference to the statutory rules where there is no will or there's no effective will. And executor, we used to routinely talk about the executor and the executrix. We tend now to simply talk about the executor. Likewise, testator or testatrix, we tend now to simply talk about the testator. And hopefully that will be a growing trend in law where we just have a general neutral, genders neutral terminology used. Okay, one little trap for young players is this. I guess you know what a will is, a document that is signed and has effect upon your death in terms of a number of things, appointing someone to take control, providing for the distribution of your estate, things of that nature. So that's a will. A power of attorney is often signed at the same time, or in the same sitting, if you like, as when a will is signed, but it's an entirely different document. It has a different effect. And a power of attorney is a document that confers upon someone else power to make decisions as a substitute decision maker for you while you're alive. The effect of a power of attorney is this. Upon your death, the power of attorney comes to an end. It has no legal significance at that time. And at that moment of your death, your will takes over. So you'll never have your power of attorney and your will operating at the same time. They're mutually exclusive. But they're all wrapped up as part of, if you like, estate planning, because we tend to have them created and signed at the same time. Power of attorney, of course, is a very important document in that its primary use is to allow for someone to make decisions for you in circumstances where you are no longer capable of making decisions for yourself. Yes, Greg?
So, John, what is an enduring power of attorney?
Thank you. So when we talk about powers of attorney, as opposed to wills, there are a number of types. The main types of powers of attorney are general powers of attorney and enduring powers of attorney. They're differentiated in their practicality, but also in their usefulness. Most powers of attorney, generally speaking, are enduring powers of attorney. A general power of attorney is usually prepared for a specific time, a specific purpose, and for a particular circumstance. So it may be that someone who is a property developer signs a power of attorney, a general power of attorney, in favour of, say, a solicitor to sign documents relative to the subdivision, but it comes to an end at the end of that. So even though we call it a general power of attorney, it's usually got a specific purpose for time, etc. An enduring power of attorney is one that will endure beyond your lack of capacity. So I should go back one step and say a general power of attorney comes to an end if you lose capacity or if you die. So if you lose the capacity to understand and make decisions or even sign or create a power of attorney, then a general power of attorney comes to an end at that stage. So, gosh, I'm trying to think when enduring power of attorneys came into existence in Queensland. It was within my legal lifetime. So we had this introduction of enduring power of attorneys, and the idea was this, that you sign the document now, the enduring power of attorney, and it will have effect even though you lose capacity to make decisions. And in fact, for the most part, many people create the power of attorney, the enduring power of attorney, such that it does have effect at that time that you lose capacity. So an enduring power of attorney, like a general power of attorney, can have immediate effect in relation to financial matters, or you may say that in relation to financial matters in an enduring power of attorney, it will come into effect if and when you lose capacity to make your own decisions. In relation to health and personal matters, then under an enduring power of attorney, you confer that power to be effective if you lose capacity yourself. I hope that makes sense. That was a lot of words, Greg, to explain what should be simple.
It was, John, but it was a very important question. Tasman's asked a very good question. Are the state trustees usually enduring powers of attorney? And she actually said there, I meant general powers of attorney. I think that's what Tasman meant. She may be able to quote us or change it up as if I've stated that incorrectly.
There's no hard and fast rule on that. The power of attorney could be a general power of attorney, or it could be an enduring power of attorney. So let's see, I don't often see the trustee companies acting as attorneys as such. I tend to see them as administrators or guardians, and that's a different concept again, as substitute decision makers. I'm not sure to what extent the public trustee, for example, would be prepared to act as someone's enduring power of attorney. In my experience, I haven't seen it much, but perhaps that's because in the tribunal, they do with Centrelink. Okay. So when I say the tribunal, I mean QCAT, the Queensland Civil and Administrative Tribunal. A big part of my bread and butter in that tribunal is making decisions about powers of attorney, making decisions about guardianship and administration, substitute decision making generally. So I just don't see a lot of EPAs. I'm struggling actually to think of one where there was appointment of the public trustee of Queensland. But usually I very often appoint the public trustee of Queensland as an administrator. Oh, I'm getting confusing now. I hope that's not too confusing. All right, but good questions. Now, when you come to draft a will, you are the testator. You are the person making the will. Now, what you need to remember is that you can't have a couple as testators. So never draft a will by two people. Every will you draft will be by an individual. There is a little way you can create a contract between two individuals who say, look, you know, and occasionally you get this, people come in and say, we would like our will, we want it on the same will because this is what we both want. We have to do separate wills. Then one of them will say, well, how do I know that he won't change his will if I pass on and he might remarry? Well, the answer is you can't. I mean, if everyone has the right to change their will at any time. But what you can do is create a document which is essentially a contract between the parties to say, I'll enter into this will in these terms, provided you do the same, and provided we make a contract with each other not to change those wills. Now, of course, you have the right to change your will. There's no law that says you are restrained from doing that, but you'll be in breach of the contract. So a disappointed beneficiary may be able to rely upon that contract to seek damages. We call that contract between two parties mutual wills, or a contract to make mutual wills. So that's the first thing. If you're drafting a will, make sure it's done as an individual. Make sure, of course, that when you take instructions from someone to prepare a will, they have capacity to make the will. And the whole question of testamentary capacity is a very substantial area of practice. The whole area of capacity to make decisions generally is very substantial. So again, in Queensland Civil and Administrative Tribunal, I'm dealing with capacity as it's defined in the Guardianship and Administration Act. When I'm in the Mental Health Review Tribunal, I'm considering someone's capacity by reference to a similar but different definition under the Mental Health Act. So capacity is capacity under the Mental Health Act, capacity under the Guardianship and Administration Act, or as a separate being, testamentary capacity, which is the capacity to make a will. And they're similar, but they're different. So just be on guard that if you're preparing a will, make sure that the person has the capacity to make the will. The test is a little higher if you're making a power of attorney. And the public guardian has some excellent guidelines in terms of how to go about determining whether someone has the capacity to make, say, a power of attorney. I hope that's not too confusing. So number one is a statement by an individual, this is my will. That was pretty much it. Number two, you need to revoke formal wills. You don't these days need to say revoke formal wills and codicils. It's essentially saying I revoke any wills, testamentary instruments made by me, or you can say codicils. Now, the third thing is distributing your estate. And you just got to be a little careful about the rule against perpetuities. You remember that one from trusts or equity, was it? And land law, the rule against perpetuities. Very briefly, any attempt by a testator to stop alienation, which is a transfer of property indefinitely, breaches the rule against remoteness of vesting. That is the rule against perpetuities. So the general proposition is that you can control property effectively from the grave, but you can't do it for too long. The rule against perpetuities is the lifetime of people alive at the date of creation of the trust plus 21 years, but it has to be specified life in being or lives in being, not just the whole world, but individuals or group of individuals. And in order to determine the life in being, you need to identify someone for that purpose. Have a look at section 209 of the Property Law Act, which basically provides for a statutory provision, a statutory period of 80 years as the perpetuity period. If it exceeds that, we then look to the common law position. So section 209 of the Property Law Act. Okay, the next thing that you'll probably do is appoint an executor, which is a person to take control of your estate, and that executor can be sole, joint, or joint and several, or successively in the order named. So in your will, you may say, I appoint Mary Smith as my executor, or you may say, I appoint Mary Smith and Jim Brown jointly, or jointly and severally, or successively in the order named as my executor. Then there's the scheme of distribution, which is where you're identifying specific gifts, where you're disposing of the bulk of the estate, and then very importantly, I always like to complete a will. Not that I do them anymore, but when I was a solicitor, complete the will with a direction as to residue. So take care with what is included in the will in terms of what you're distributing, because not everything that you own is distributed by your will. It's a bit of a trap, and increasingly, many people, even people with substantial assets, have very little to leave in their will. It's a bit of a conundrum, isn't it? It's a bit of it's a bit odd. What do I mean by that? Well, the things that are not included in your will that don't pass by way of your estate are generally joint tenancies, superannuation, or the proceeds of insurance. So if, for example, you're dealing with Mary Smith, who jointly owns property with Bill Brown, in the event of, and they do so as joint tenants, if Mary passes away, then under the law of survivorship or the rule of survivorship, the property would go to Bill. We don't look to the will. Even if the will says something else, that won't apply. The law of survivorship will apply. Likewise with superannuation, it's up to the trustees of the superannuation fund to distribute the estate. They may be guided by the will, but they're not bound by it. And it is possible, if you're drafting a will, to consider preparing or have your client prepare a direction, a binding resolution as to how the proceeds of the super are to be dealt with. So Tasman's another question. Debts from creditors, they can be recovered by the estate. Yes, they should be recovered by the estate. So debts from creditors, that's the terminology there. So creditors are the people that chase you for money. So C, creditors, chase, and debtors are the people that owe you money. They're the dodgers. So it's a little way of remembering those. But yes, outstanding bills. Yep. So outstanding bills should be paid by the estate. Absolutely. If they're owed or if they're to be recovered, if they're debtors, yes, chase them. That's part of the role of the executor. The next thing is that there might be some funeral instructions included in the will, but they're not formally part of the will in terms of being binding on the executor. We typically include funeral instructions, but ultimately it's up to the executor to make a decision as to how to deal with the burial or cremation and deal with the remains. Then we have the testimonium with the formal words at the end of the will, which set up the process of signing and executing the will. So that's the basic structure of a will. There's some further material in your study guides, plenty of precedents around about basic wills, and please consider reading the article by Thomas Word about a brief for plain English in wills and trusts in that regard. Now let's move on to contracts. Again, there are many standard form contracts for use in contractual matters. Those of you that have done conveyancing, I'm doing conveyancing at the moment at CQU, or teaching it rather. We talk about the standard REOQ contract, which is the norm for real estate transactions. So there are many standard contracts, but when you're drafting a contract, again, think about what Duke Mcdonald said in terms of simplicity. And think about it from the perspective of, say, the buyer. One of the preliminary things in drafting a contract for a buyer of anything is identifying, if you like, with your client, who is the suitable purchasing entity. Now, it might be the individual who's opposite you at the desk, but it may be that the individual would be better from a tax perspective or a planning perspective or a risk management perspective to set up a company or a trust and acquire property in that name. It's too late to raise these issues after the contract is signed, because then you have the very real risk of having to pay double. We used to say stamp duty, we say transfer duty now. So make sure that you get that done before the contract's signed. If you don't raise it as an issue and there's problems down the track, you may have to go and speak to the Legal Services Commissioner upon a complaint. We don't want that. I mentioned earlier joint tenancy, tenancy in common. That's something that you need to broach, consider when drafting a contract where there are multiple parties. And then go on and deal with property, performance and price. The 3 Ps. In order to have a binding contract, generally speaking, you need to have parties, property and price. If you have those 3, subject to statutory requirements, for example, that it must be in writing if it's to do with the sale of land, then you've probably got enough to enforce the contract, even if you don't have anything stated about the deposit or conditions such as finance or a date for settlement. You can imply those terms in some circumstances, or they're not implied in at all. But you need the property, the parties and the price. Remember those statutory requirements, for example, the note or memorandum in writing for the contract of sale of land. Have a look at sections 11 and 59 of the Property Law Act Queensland, 1974? Yeah, 1994. Now I'm getting confused. I say it so often. I think it's 1994 now. 74, says Andrea. Thank you, Andrea. Thank you. Maybe I'm thinking of the Land Title Act and the other piece of legislation at that time. When you're drafting a contract, Land Title Act, when you're drafting a contract, think about the consideration, think about the deposit. Remember, there are some special rules. If the deposit exceeds 10% in relation to a contract for the acquisition of real estate, then it's deemed to be an instalment contract. Special rules apply. Again, look at the Property Law Act. When you're drafting a contract, consider risk and insurance. The risk usually should stay with the buyer, and the buyer should take out insurance against the risk of something going wrong. For all sorts of technical reasons, be very cautious about redrafting a contract such that the risk stays with the seller. Because in equity, a buyer is the equitable owner of the property once the contract is signed. So by having the risk stay with the seller, there's a mismatch there. And it's better that the risk stay with the buyer because the buyer has the equitable interest. When you're drafting a contract, think about the mechanisms for a breach, which may include forfeiture of the deposit, whether the parties may affirm and sue for damages, affirming as a lead into seeking an order for specific performance, or whether the parties may terminate and sue for damage and forfeit the deposit. And all of that in the context of the contra preferentum rule, where there's the ambiguity in the contract, is against the person relying on the ambiguous term, the one that drafted the contract. All right, now, are there any questions? I know that was a quick overview. Are we all good? All right. Now that is the end of week 12 material, which therefore means by definition, that is the end of the unit. I'm still around. I've still got many papers to write, and I'll encourage you, if you haven't already done so, to upload your second submission. And as soon as you can after that, upload your third submission, which is your participation record. There's no prescribed form for the participation record. What I'm really after is for you to, for want of a better term, cut, paste, or link to material which will make it easy for me to find a reference to the material that justifies your participation. So, for example, if you've participated in each of the Zoom sessions live, please let me know. Maybe do up a chart, 1 to 12, participated live or viewed it at a later time. If you say you viewed it at a later time, guess what? I'm going to take your word for it. We haven't reached third year unless we've got a degree of trust. If you've contributed something into UCrew, please cut, paste that if you would, into the Word document that you upload for your third assessment piece. There's no word count on the third assessment piece. So the general rules in relation to assessment don't apply. Lodgement of material don't apply, but you can always present it nicely, use footnote referencing, etc. as well if you would. Any questions then about the content of tonight, the content of the unit generally, or the assessment pieces 2 and 3 yet to come? All good? Thank you. Now, while just as in wrapping up, please ask a favour. It's a small group. How important is the layout of the second assessment? No, don't worry too much about the layout of the second assessment. I'm really very keen to ensure that you have something that is internally consistent, that you use headings in the same way, that your styles are consistent, that your referencing should be AGLC, but there's an impressive look about it, but don't be too flowery. Just make sure it's consistent and there's no particular layout. I hope that answers your question, but it's a good one. All right, now if you would please take a couple of moments to have your say. That feedback, top left-hand corner, big red button, click, have your say. That's very important for the university. It's very important for me And it's very important for all of your unit coordinators. So not just me, but please everyone, take some time to have your say. All right, well, I'll wrap up for this evening. I'm still around on uCrew, email. There'll be no session next week, but I'll give you generally some feedback in relation to the third assessment, and I will provide specific feedback in relation to the second assessment. All the best. I'll sign off now, and we'll see you next time. Thank you.